I have spent decades wearing this black robe, looking down from the bench at the full spectrum of human nature. I have seen genuine remorse, I have seen absolute desperation, and I have seen cold, calculated greed. But there are certain cases that burrow into your memory and refuse to leave. This is the story of one of those mornings, when the heavy wooden doors of my courtroom swung open and Julian Vance strode down the center aisle. The air in the room seemed to change. He didn't just walk, he paraded, carrying the distinct, untouchable aura of a man who believed the rules applied to everyone but him. Before I explain the evidence that would eventually dismantle his world, you need to pay attention to the silence in that room. Justice is rarely about the final gavel strike. It is about the quiet, heavy moments leading up to it. On paper, the docket described a standard civil dispute, a breach of contract, a property transfer, financial damages. It sounded clinical, but as any experienced judge will tell you, paperwork is often a sterile mask, hiding a deeply human tragedy. The plaintiff was Evelyn Hayes, a 8-year-old widow. She sat at her counsel's table looking remarkably small, dressed in a faded but meticulously ironed floral dress, the kind someone saves for church or funerals. Her hands, trembling slightly, were clasped tightly around a worn leather handbag. She didn't look angry. She looked profoundly exhausted, the kind of exhaustion that comes from fighting a battle you know you don't have the weapons to win. Yet, her chin remained lifted. There is a quiet, unbreakable dignity in people who have survived a lifetime of quiet hardships. Opposite her sat the defendant, Julian Vance, a 32-year-old multimillionaire CEO of a rising real estate tech firm. Everything about him was engineered to project superiority. His tailored suit cost more than Evelyn's yearly pension. As he took his seat, he didn't look at the judge, and he certainly didn't look at Evelyn. Instead, he casually checked his expensive smartwatch, letting out a soft, impatient sigh, as if this trial was merely a minor traffic jam on his road to greater success. He leaned back, whispering something to his team of high-priced corporate attorneys, and flashed a brilliant, rehearsed smile. That smile caught my attention immediately. When a person is accused of stripping an elderly woman of her life savings and they respond with a smirk, they are telling you exactly who they are. I watched the two of them, one possessing limitless resources and staggering arrogance, the other holding on to nothing but the hope that the law still protects the vulnerable. Appearances, however, can be deceiving. I reminded myself of that as the court was called to order. The stage was set, the opening statements were about to begin, and Julian Vance was absolutely certain he was going to walk out of my courtroom a free, richer man. He was incredibly wrong. The opening statements began, and the contrast between the two tables became even more glaring. Julian's lead attorney, a man whose hourly rate likely exceeded Evelyn's annual pension, stood first. His voice was incredibly smooth, dripping with the kind of condescending patience usually reserved for explaining mathematics to a toddler. He painted a picture of a standard, albeit unfortunate, business transaction. According to the defense, Julian's tech firm had made a generous offer to purchase Mrs. Hayes' home of 40 years. The attorney claimed she signed the digital contracts willingly, and her lawsuit was simply a case of seller's remorse, fueled by a misunderstanding of modern real estate platforms. He made it sound so logical. A simple misunderstanding by an elderly woman confused by technology. Then, Evelyn's attorney stood. He didn't have a tailored suit or a team of associates. He had a single manila folder. He spoke about predatory deception. He detailed how Julian's company didn't just buy Evelyn's home. They had buried a convoluted equity stripping clause in a 140-page digital terms of service agreement. It was a document they rushed her to sign on a tablet she barely knew how to operate, while Julian himself stood in her living room, falsely assuring her she would be allowed to live there rent-free for the rest of her life. I watched Julian during this. Most defendants facing allegations of elder exploitation attempt to look sympathetic. Julian was actually rolling his eyes. At one point, he let out a scoff so loud I had to strike my gavel and remind him of where he was. He offered a half-hearted apology, but the smirk never left his face. He believed his airtight digital contract was his impenetrable shield. He believed the law was just a game of semantics his lawyers had already won. But a courtroom is not a boardroom, and I do not tolerate corporate bullying disguised as legal strategy. I asked the plaintiff to call their first witness, and Evelyn Hayes slowly made her way to the stand. The room fell perfectly silent as she raised her trembling right hand to swear an oath to tell the truth. Evelyn Hayes adjusted the microphone. When she spoke, Her voice was quiet but carried a tremor that resonated through the courtroom. She didn't possess the polished vocabulary of a corporate lawyer. She simply told her story. She explained that after her husband passed away, Julian's company had aggressively targeted her neighborhood. They sent glossy brochures, made unsolicited phone calls, and eventually, Julian Vance himself arrived at her doorstep. She testified that he was charming, referring to her as ma'am, and promising that his company's legacy program was designed to help seniors cash out their home's equity while guaranteeing they could live there rent-free until they died. "He looked me in the eye," Evelyn said, gripping the edge of the witness stand. "He told me I would never have to worry about a mortgage again. I trusted him. He seemed like such a nice young man." The plaintiff's attorney then projected the contract onto the evidence screens. It was a digital labyrinth of legal jargon. He highlighted Section 4, Paragraph 12, Subclause C, the specific clause that stripped Evelyn of her rent-free status the moment she missed a single arbitrary maintenance fee, a fee that Julian's company had quietly increased by 400% within the first 6 months. When she couldn't pay, they initiated eviction proceedings. Evelyn wept as she described receiving the notice, realizing the home she and her late husband had built was gone. The jury was visibly moved. Several members glared openly at the defense table. Julian's attorney stood for cross-examination. His strategy was clear: dismantle the old woman's credibility by exposing her technological illiteracy. He badgered her about IP addresses, digital signatures, and electronic addendums. "Mrs. Hayes," he asked, leaning heavily on the podium, "is it not true that you physically tapped the I agree button on the tablet provided to you?" Evelyn nodded slowly. "I did. But he told me." The attorney cut her off sharply. "A simple yes or no, please. You agreed to the terms." It was a brutal, effective tactic. In the eyes of the law, a signature often outweighs a verbal promise, no matter how deceptive. The defense rested their cross-examination looking triumphant. Julian Vance actually checked his watch again, a gesture of supreme, unchecked arrogance. He thought the trial was practically over. He believed his money and his digital trap had outsmarted a grieving widow. But arrogance often blinds people to the one thing they cannot control: the truth hidden in plain sight. As Evelyn stepped down, looking diminished but resolute, Julian Vance leaned back in his leather chair, crossing his arms. He actually winked at his lead counsel. He believed the trial was a formality now. The defense had established that Evelyn signed the document. In corporate law, ink, or in this case, a biometric digital stamp, is often considered absolute. But this courtroom is not a corporate boardroom, and justice requires context. The plaintiff's attorney stood up. He didn't look defeated. "Your Honor," he began, his voice steady, "the defense has made much of the digital signature. We do not dispute that Mrs. Hayes' finger touched that screen. We dispute what was happening in the room at the exact moment she did." He then submitted Exhibit C. It wasn't a printed document. It was an encrypted audio file. He calmly explained to the court that the proprietary software Julian's company used for on-site acquisitions had a built-in compliance feature. It was a fail-safe designed to protect the company from fraud by recording ambient audio during the final signature sequence, a feature Julian, in his supreme overconfidence, had apparently forgotten to disable on his own company tablet. For the first time all morning, Julian Vance sat up straight. The relaxed, mocking posture vanished entirely. His lead attorney scrambled to his feet, objecting vehemently. "Your Honor, this is an unauthorized recording. It violates privacy statutes," he stammered, his polished veneer cracking under the sudden pressure. I looked down from the bench, fixing my gaze on the defense. "Counselor," I said, "this is your client's own software." He brought it into the plaintiff's private home. "Are you telling this court that your client's company illegally records its customers without their consent?" The attorney froze. It was a trap entirely of their own making. If the recording was illegal, the company was admitting to a massive, systemic privacy violation. If it was legal and standard protocol, it was admissible evidence. He slowly sat back down. I overruled the objection. The courtroom held its collective breath as the plaintiff's attorney pressed play on the audio system. "The digital contract Mrs. Hayes signed," the attorney explained, his voice echoing clearly across the room, "was generated on a tablet owned and operated by Mr. Vance's company. As per their own internal compliance protocols, the device automatically records the final 60 seconds of the transaction to prevent claims of coercion. A feature, I might add, they rarely disclose to their clients." He clicked a button on his laptop. The courtroom speakers crackled to life. First, there was the sound of rustling paper, then Evelyn's voice, sounding hesitant and fragile. "Julian, dear, are you absolutely sure about this? The print is so small. I just want to make sure I don't lose my home." Then, Julian Vance's voice filled the room. It wasn't the polished, measured tone he had used with his attorneys. It was smooth, but laced with a predatory impatience. "Evelyn, I promise you, this is the legacy program. You sign this, you stay here rent-free for the rest of your life. My word is my bond. Just tap the button right there at the bottom. We'll take care of everything else." There was a soft beep as the digital button was pressed. Then, the sound of a door closing. The recording didn't end there. The tablet was apparently still recording as Julian walked out to his car. The audio captured him speaking to an associate, his voice now a cold, triumphant sneer. "Did you get it?" a second voice asked. Julian laughed, a sharp, cruel sound, like taking candy from a baby. "She didn't read a damn word. Initiate the fee hike in 6 months. We'll have her out of there and the property flipped by Christmas." The recording clicked off. The silence that followed was absolute. It was the kind of silence that precedes a storm. I looked at the jury. Several of them were staring at Julian with expressions of pure, unadulterated disgust. I then looked at Julian Vance. The arrogant smirk was entirely gone. His face had drained of color, his mouth slightly open. He looked exactly like what he was, a bully who had just been caught. He turned frantically to his lead counsel, but the high-priced attorney was staring straight ahead, his jaw clenched, realizing his client had just handed the plaintiff the smoking gun. Power and privilege can buy many things, but they cannot buy a way out of your own recorded words. The echo of Julian Vance's cruel laughter faded into the wood-paneled walls of my courtroom, but its impact lingered like a physical weight in the room. I have seen many forms of capitulation in my career. Sometimes it is a slow, quiet surrender. Other times, it is a sudden, catastrophic collapse. Julian's was the latter. The man who had walked into my courtroom with the swagger of a modern-day emperor was now shrinking into his bespoke suit. He leaned toward his attorney, whispering frantically, his hands gesturing with a desperate, uncoordinated energy. His lead counsel, however, remained completely still, his posture rigid. An experienced lawyer knows when a case has flatlined, and he knew that the encrypted audio file had just severed their only lifeline. The plaintiff's attorney did not gloat. He simply turned back to Evelyn Hayes, who was wiping a single tear from her cheek, and said, "No further questions for this witness, Your Honor." I dismissed Mrs. Hayes and turned my attention to the defense table. "Counselor," I said, my voice cutting through the murmurs of the gallery, "does the defense wish to call Mr. Vance to the stand to explain his definition of taking candy from a baby?" Julian Vance took the stand. The confident, rehearsed stride was gone. He walked like a man approaching a sheer drop. When he took the oath, his voice cracked. Under the questioning of his own attorney, Julian attempted a frantic pivot. He claimed the recording was taken out of context. He argued that candy from a baby was merely aggressive corporate slang for an easy transaction, not an admission of predatory intent. He insisted that the fee hikes were standard market adjustments, not a deliberate strategy to force an elderly woman onto the street. He spoke rapidly, stringing together business buzzwords, hoping that corporate jargon could mask moral bankruptcy. But I was watching the jury. They weren't listening to his buzzwords. They were looking at his eyes, which darted nervously around the room, and his hands, which gripped the edge of the witness stand so tightly his knuckles were white. He was no longer trying to win. He was just trying to survive. The plaintiff's attorney stood up for cross-examination, holding the digital contract. "Mr. Vance," he began softly, "let's talk about this transaction." The plaintiff's attorney approached the podium. He didn't raise his voice. He didn't need to. The silence in the room was doing the heavy lifting for him. "Mr. Vance," he began, placing a physical copy of the contract on the evidence screen. "You testified a moment ago that the phrase, 'taking candy from a baby,' referred to an easy corporate transaction. Let's examine the exact mechanics of that transaction." He pulled up a digital timeline. On May 1st, Mrs. Hayes' mandatory maintenance fee was $150. On November 1st, it was $600. A 400% increase in exactly 6 months. You claim this was a standard market adjustment. Can you point to a single other non-legacy property in your entire portfolio that saw a 400% increase in that same time frame? Julian shifted uncomfortably in the witness box. His expensive tailored suit suddenly seemed too tight. Real estate markets are highly volatile, he deflected, his voice defensive and sharp. Our algorithms automatically adjust for projected neighborhood value and maintenance inflation. It's standard tech-driven management. Your algorithms, the attorney repeated slowly, letting the coldness of the word hang in the air. He then introduced Exhibit D, an internal company email thread obtained during discovery. This is an email sent directly from your account to your chief financial officer on April 15th. It reads, and I quote, "The legacy demographic is successfully locked in. Trigger the fee acceleration protocol. Most of these seniors are on fixed pensions. They'll default on the new fees by Q3, and we take full, unencumbered possession of the deeds." End quote. A collective, audible gasp swept through the gallery. I struck my gavel hard. "Order," I commanded, my eyes fixed sharply on the defendant. Julian's face was now flushed with a volatile mix of panic and deep indignation. The polished, untouchable CEO had vanished entirely, replaced by a cornered predator whose trap had just snapped shut on his own leg. That is proprietary internal strategy," Julian stammered, pointing a shaking finger at the plaintiff's attorney, completely forgetting his audience. "You don't understand how modern business works. We are optimizing underutilized assets. People like her are sitting on prime real estate they can't even afford to maintain. We are doing the housing economy a favor." He had done it. In his desperation to defend his intellect and his business model, he had abandoned his humanity completely. He didn't see Evelyn Hayes as a person, a widow, or a human being. He saw her merely as an underutilized asset waiting to be optimized for his profit margin. "She signed the paper," Julian suddenly yelled, slamming his open palm onto the wooden ledge of the witness stand. "It's not my fault she's too obsolete to understand a digital contract. Business is business." No one objected, not even his own high-priced attorneys. They sat frozen at the defense table, realizing that Julian Vance had just successfully prosecuted himself. You see, the law can spend weeks debating the semantic definition of a digital signature, but a jury evaluates the character of the person enforcing it, and Julian had just shown them a character entirely devoid of a soul. The jury didn't need to deliberate long. In cases where the defense's strategy is built entirely on the presumption of their own superiority, the collapse is usually swift and total once that presumption is shattered. The verdict was a resounding victory for Evelyn Hayes. The jury found Julian Vance and his company liable for predatory business practices, fraud, and intentional infliction of emotional distress. They voided the contract entirely, returning the deed of the house to Mrs. Hayes, and awarded her a staggering sum in punitive damages, an amount designed not just to compensate her, but to send a shockwave through Vance's entire industry. When the foreperson read the verdict, Julian did not stand. He sat slumped in his chair, staring blankly at the polished mahogany table. The arrogance that had defined his entrance was gone, replaced by the hollow realization that all his wealth and technological savvy had failed him. When it was my turn to speak, I addressed him directly. "Mr. Vance," I said, the courtroom hanging on every word, "you built a business model on the assumption that the elderly are obsolete, that compassion is a weakness, and that a digital contract is an impenetrable shield against basic human decency. You mistook a lack of technological fluency for a lack of intelligence, and you mistook a grieving widow for an easy target." I paused, letting the silence emphasize the gravity of the moment. "You thought you were the smartest person in the room, but true intelligence isn't just about writing code or optimizing algorithms. It's about understanding the impact of your actions on the people around you. You are not a pioneer, Mr. Vance. You are simply a very well-dressed thief." Evelyn Hayes walked out of the courtroom that day with her head held high, clutching her worn leather handbag. She didn't look like a victim anymore. She looked like a survivor. Julian Vance walked out shortly after, flanked by his attorneys, aggressively ignoring the cameras waiting in the hallway. Months later, I read that Julian's company was facing multiple federal investigations and a class action lawsuit from dozens of other seniors who had been similarly targeted by the legacy program. His board of directors forced him to resign. People often ask me if cases like this make me cynical about human nature. The truth is exactly the opposite. While it is disturbing to see how far some will go to exploit the vulnerable, it is profoundly reassuring to witness the system working as it should. Justice is not always swift, and it is rarely perfect, but on that day, in my courtroom, it proved that no amount of money, arrogance, or digital deception can permanently hide the truth. Character, ultimately, is what remains when power fails.